Today, we're diving deep into one of India's most ambitious economic reforms ever, the Insolvency and Bankruptcy Code, or the IBC. Now, this law didn't just tweak the rules for failing companies, it basically tore up the old playbook and started from scratch. And using a really detailed parliamentary review as our guide, we're going to unpack what it's achieved, and maybe more importantly, expose where this billion-dollar fix is now under some serious strain.
All right, so to really get why the IBC was such a massive deal, we have to rewind the clock. We need to go back to the world before 2016. Because back then, you had this massive economic logjam, a kind of gridlock, where billions upon billions of dollars were just trapped, holding the entire economy back.
I mean, just think about that question for a second. Before the IBC, this wasn't just a hypothetical, it was a real paralyzing problem. You had these huge, what people called zombie companies, that were basically failing but couldn't be shut down, couldn't be saved, they just existed, sucking up huge amounts of money and resources that could have gone somewhere else.
Yeah, the old system was just this tangled mess of different laws, some of them were a century old, and they just didn't work together at all. The result? You had valuable assets, factories, machinery, capital, stuck in legal limbo for years, sometimes even decades. And the lenders, the banks that put up the money, they had practically no power to get it back, which made investing in Indian businesses a huge risk.
Then in 2016, boom, everything changed. The government brings in the Insolvency and Bankruptcy Code. This was meant to be a single, modern rulebook designed to break that gridlock, once and for all.
So what is the IBC, really? Well, at its core, it's a unified law built to resolve corporate distress, and to do it quickly. The two magic phrases you got to remember here are time-bound and maximization of value. See, the goal isn't just to sell off a failing company for parts. The first priority is to try and rescue it. And if that's not possible, then you liquidate it as efficiently as you can to get the best possible value for everyone involved.
Now this, right here, this is probably the single biggest philosophical change the IBC brought in. Before, the very same promoters who defaulted on their loans and, ran the company into the ground, they stayed in charge of the process. It was wild. The IBC flipped that completely on its head. Now, the second a company defaults, control shifts to the creditors, the banks, the lenders. They get in the driver's seat and decide what happens next. It was an absolutely revolutionary shift in the balance of power.
Okay, so to actually make all this work, the IBC created a whole new ecosystem, and it's built on these four key pillars. First, you've got the insolvency professionals, or IPs. Think of them like temporary CEOs who manage the whole process. Second, you have information utilities. These are basically centralized digital databases that keep a record of all the debt. Third, you have the courts that rule on the cases. And finally, you have the IBBI, a really powerful regulator that oversees the entire system.
So the system looks great on paper, right? But how's it actually performed over the last 8 years or so? Well, let's look at the report card. And it's a fascinating story of some incredible successes and some very, very real strains.
Okay, let's start with one of the most powerful but kind of indirect benefits of the whole thing. Check out this number, nearly 14 lakh crore rupees. That's the amount of money that was settled just because a creditor threatened to file an IBC case. The fear of losing their company was enough to make defaulting owners suddenly find the money to pay up. This proves the IBC didn't just create a new process, it totally changed the behavior and the relationship between debtors and creditors in India. And you can see the direct impact right here. When it comes to actually recovering money from bad loans, the IBC is now, without a doubt, the undisputed champion. In the last financial year, it was responsible for almost half of all the money banks got back. That's more than the older methods like the Insolvency Act and the debt recovery tribunals combined. It's just the most effective tool they have.
And here's another huge piece of good news. This chart, straight from that parliamentary report, it shows the ratio of companies being rescued versus those being liquidated or sold off. Now, in the early days, way more companies ended up on the chopping block. But look at that trend line just shooting up. The system is getting much, much better at its main goal, resolving the problem and saving businesses that are still viable. In fact, recently, for every one company that gets liquidated, nearly 2 are being successfully rescued. That's a huge win.
But this brings us to what you could call the great IBC paradox. On the one hand, look at this. The recovery is fantastic compared to the alternative. Lenders get 170% of what they would have gotten in a fire sale. That's a massive success. But on the other hand, they're only getting back about 33% of their original loan. That means they're taking a nearly 70% loss, what they call a haircut. So, is it a success or a failure? Well, the answer is kinda both. It's the best option available, but it's an option that still comes with a very heavy price tag.
And here is the other major strain on the system: delays. Remember that time-bound thing? The law was designed to be fast, with a hard limit of 330 days to close a case. But the reality? The average case is taking 713 days. That's more than double the legal limit. You've got court backlogs, endless litigation. It's slowing the whole process to a crawl. And of course, with every single day that passes, the value of those company assets just erodes.
So yeah, these delays and these big haircuts are putting the entire system under a lot of pressure. So now we're going to zoom in on two specific friction points: how the IBC is affecting India's smallest businesses, and the conduct of the very powerful professionals who are actually running the process.
This is such a critical question. Micro, small, and medium enterprises, the MSMEs, they're the absolute backbone of the Indian economy. But the IBC is this big, powerful tool that was really designed for massive corporations. So, how does it work for the little guy?
Well, the lawmakers knew this could be an issue, so they built in some specific protections. For one, small business owners aren't banned from bidding to get their own company back, unlike with large corporations. Second, the minimum default to even start a case was raised to 1 crore rupees, which helps shield a lot of smaller firms. And, most importantly, they created a whole special, streamlined process just for them, known as the pre-packaged route.
So they created the solution, right? Well, here's the reality check. Since it was introduced, only 14 cases, 14 have been admitted under the special process for small businesses. That number is just astonishingly low, and it shows there's a huge disconnect somewhere. The tool that was designed specifically to help MSMEs simply isn't being used. And the report suggests it might be because it's still too complex, or that banks just prefer other ways of getting their money back.
Now let's turn to that other pressure point: the professionals who are right at the heart of the system. These resolution professionals, or RPs, they have immense power. I mean, they literally take over entire companies. So as the head of the regulator told the parliamentary committee, they need a carrot and stick approach to keep them in line. And that stick is very, very real. This table shows that the regulator is actively policing its own. Just last year, 45 of these professionals were suspended, 13 got hit with fines, and 3 actually had their licenses canceled for good. The crucial point here is that while these guys have a ton of power, there is a strong system in place that's trying to hold them accountable. So, what's the takeaway? The IBC is a powerful but clearly imperfect tool, and it's constantly being debated, refined, and changed. Let's wrap up by just looking at what's next for this billion-dollar fix. Right, this law is not static, it's constantly evolving, and there are already new amendments being planned to tackle these new challenges. They're working on rules for international cases, which is known as cross-border insolvency. They're also figuring out what to do when an entire corporate group fails at once. And really importantly, they're trying to close a loophole that some wealthy guarantors have been using to dodge their obligations. And that really leaves us with the big central question that defines this whole experiment. The IBC is, at its heart, a balancing act. It's about trying to find that incredibly difficult middle ground between the cold, hard logic of economic efficiency on one side and the very real, very human needs of all the different people involved on the other. Finding that balance is, and will continue to be, the IBC's greatest challenge.